What would you like to talk about? The final, a week from tomorrow, at 11:30, and it's 3 short answer questions and worth a total of 10 points, and 25 true-false questions worth 1 point each, for a total of 35 points. Take you about 20 minutes, half an hour maybe. Starts at 11:30 in F295, which is the auditorium in the Haas Business School, not Haas Pavilion. And don't come late thinking you've got 3 hours or something to do it, because we'll close up by 1 o'clock at the latest. The test is not fully cumulative, and all of the questions will be about material since the midterm. What else do you need to know? False speech? Starting at false speech. So let's start with false speech. And the main cases, of course, are Dorsey, the Engelbert Humperdinck extravaganza, his lawsuit against the National Enquirer. The main interest of that case, for our purposes, has been to identify the common law elements of the tort of defamation. We pretended as though the case was decided before New York Times versus Sullivan, which is the case on libel, and a really central case in the history and contemporary meaning of freedom of speech and the press. So you should be very familiar with New York Times versus Sullivan. And then ending up the false speech section was the liar case, United States versus Alvarez, which was decided last year, and threw out the conviction of Alvarez for lying about receiving the Congressional Medal of Honor. And the questions posed in this section of the course are: what limits does the First Amendment place on the power of the states to protect their citizens' reputations? Well, the way in which states protect their citizens' reputations is through their own law of libel, protecting the interest that we all have in our good name, our reputation. And libel has been part of the common law since the very beginning, still is today. States still protect their citizens' reputations through the law of libel, but since New York Times versus Sullivan, limits have been placed on the power of the states to protect reputation, imposed by the First Amendment, so that every libel case now is a First Amendment case too. And everybody who sues for libel has to prove the common law element, plus comply with the constitutional fault requirements imposed by New York Times versus Sullivan. That is, if you're a public figure or a public official, you have to prove what the court called actual malice, now called more properly constitutional fault, because it doesn't have anything to do with malice as we normally understand the word. Rather, it has to do with the publisher's state of mind vis-a-vis the truth. Did the publisher know that the statement was false, or publish with reckless disregard for the truth? That's what constitutional fault means. And even if one is a private figure suing for libel, the court said in the Gertz case that some kind of fault must be required by every state, and the states have divided on whether they require even private libel plaintiffs to prove constitutional fault, actual malice, or whether they need only prove negligence. California has opted for negligence. So what's the central meaning of the First Amendment? The court in Sullivan, in reviewing the history of the Sedition Acts, that unhappy episode in our constitutional history, when the Congress enacted the Sedition Act to silence Republican critics of the Adams administration in the late 1700s, the court said that the experience, our national experience with the Sedition Act, crystallized the central meaning of the First Amendment. And if you follow Justice Brennan's history and his meaning there, what he's talking about is the right that we all have as citizen critics of government to criticize government and government officials. It's not necessarily a freedom of the press case, though it involved the freedom of the New York Times to publish criticism of the police chief of Montgomery, Alabama. But the central meaning of the First Amendment has meaning for all of us as citizen critics of government. Why are the common law protections of the press still important? Well, as I said, anybody who's suing for libel still has to prove the common law elements of the tort, and then, or in addition, comply with the constitutional requirements of Sullivan. Plus, as a practical matter, it's frequently easier, cheaper, more expeditious to get out of a libel suit on common law grounds rather than fight the First Amendment battle. That is, if the plaintiff has not established that the defamatory statement is of and concerning him, that is, about him, there's no case. If the statement is privileged, the way it was in the Dorsey case, then there's no case. And the common law requirements protect the defendant publisher without ever having to deal with whether there is constitutional fault. Are false statements of fact ever protected by the First Amendment? Sure. They're protected in libel cases even if the plaintiff cannot prove the requisite degree of fault. And the big false statement case these days is Alvarez, where the government contended that false statements of fact fall into a category of speech that is not protected by the First Amendment at all. And the court rejected that categorical approach and decided that the mere fact, as lawyers like to say, the mere fact that something is false does not deprive it of constitutional protection. This seems to have to be something more, like the false statement caused actual harm, or the false statement was made in order to gain some benefit. But in Alvarez, it was a simple lie that had no effect on anybody, and the court found that the government lacked the power to punish the utterance of a falsehood without more. So we're going to just do this stuff. Feel free to ask any questions as you go, as we go. You can come back to something if you want, but please interrupt me if anything is uncertain in your mind. Yeah, well, we covered the two privileges that most commonly arise or might be issues in libel cases: fair report and fair comment. Fair comment deals with expressions of opinion rather than fact. And the privilege protects statements of opinion that are honestly held, you really do believe it, and are about a matter of public concern. So that common law privilege protects book reviewers, restaurant reviewers, editorial writers, people who generally deal in opinion. The fact that you couch something in opinion-like terms, that is, I think Turner committed murder, does not protect it. The Supreme Court decided, you don't need to know this, but the Supreme Court decided that there is no special First Amendment protection for expressions of opinion. But the question is a statement provably true or false? If it's not provably true or false, if it's rhetorical hyperbole, just off the wall, unbelievable stuff, then paradoxically it's protected by the First Amendment because it's not provably true or false. The fair report privilege is the one that was used in the Dorsey case that protects false statements made about government proceedings, what happens in court, what happens in the legislature, what happens in any governmental proceeding, and allows the press, this is not limited to the press, but predominantly a protection for the press, allows the press to report what's going on in those government proceedings, even though somebody is falsely accused in the court or in the legislature of having done something awful. And even if the reporter who writes the story knows that it's false, there's still an absolute, at least in California, protection for statements about what goes on in those governmental proceedings. Injurious speech, my own word for this category of speech, where we dealt with Hustler versus Falwell, Hustler versus Hersig, the autoerotic asphyxiation case, the American Booksellers case, the attempt by a city ordinance to make pornography, to have it treated by the legal system as sex discrimination against women, and finally the violent video games case. Those are the principal cases that we dealt with. The questions to think about are, can a public figure sue the press for intentionally inflicting emotional distress? The short answer, yes. Anybody can sue the press, and you can come up with whatever theory you want. The question is whether you can successfully sue. And Jerry Falwell sued for, among other things, intentionally inflicting emotional distress by publishing the dirty joke caricature of him in Hustler magazine, saying that he had had sex with his mom in an outhouse. He claimed that violated his common law right to be free of intentional infliction of emotional distress. The jury awarded him damages for that. The Supreme Court reversed the judgment, found that Hustler could not constitutionally be liable. And there were a couple of reasons for the court's conclusion, principal reasons. One is that proof of intentional infliction of emotional distress requires the plaintiff to prove that what the defendant did was intentional and caused emotional distress, but the guts of it is that whatever the defendant did has to be outrageous. And the Supreme Court found that outrageousness is such a subjective standard that it couldn't safely be used to create liability. Juries might feel free, given that wide-open outrageousness standard, to punish speech that they don't like or speakers that they don't like, and that is a big threat to free speech. The other thing that the court emphasized and that protected Hustler in the Falwell case was that Falwell is a big-time public figure, very influential person in American society, and under the reasoning of New York Times versus Sullivan, people ought to be able to criticize him, to poke fun at him, to skewer him, to parody him, to try and paint him as a bad person. And they should be free to do that unless, the court said in the Hustler case, a false statement of fact is made with constitutional fault, with knowledge of its falsity or reckless disregard for its truth. But the court found, the jury actually in the trial court, rejected Falwell's libel claim because no reasonable reader would have believed that the accusations in the parody cartoon were true. Everybody would have assumed they were false, and therefore there was no false statement of fact that Falwell could pin his case to. In the other Hustler case, the Hersig case, that didn't involve false statements of fact at all. It involved truthful information about the practice of autoerotic asphyxiation that caused not just injurious speech, but death of the kid who tried it out. And he lost, his mother and survivors lost the case, the wrongful death case against Hustler, because what they claimed was that Hustler had incited the death. And the Court of Appeals decided that a written article in a magazine couched with warnings, don't do this, don't try it, it's dangerous, could not be considered incitement within the meaning of Brandenburg versus Ohio. That protects even the advocacy of dangerous ideas. Does parody have special First Amendment protection? No, there's no special category of parody. It says there's no First Amendment rule that says parody is protected speech. It was protected in the Falwell case for the reasons that I gave, but there isn't, as there's no special protection for opinion, there's no special protection for parody either. To what extent can government shield children from exposure to violence in the media? Well, we've encountered that in several different contexts now. When government attempts to protect children by legislation that singles out certain kinds of speech as, in the view of the government, harmful to minors, like, for example, the California violent video games case, like the Communications Decency Act, and so on, the laws are content-based. That is, they target the speech as illegal because of the content of the speech. And that triggers, as we know so well by now, strict scrutiny, requiring the government to prove that the restriction on speech is meant to serve a compelling government interest, and the restriction specifically is narrowly tailored to protect that interest. That the law is not overbroad, sweeping within its ambit speech that is protected. We saw in the violent video games case, the government attempted to create a new category of speech unprotected by the First Amendment, saying that extremely violent video games are of so little social value that they should not be protected under the First Amendment at all. And the court rejected that contention, as it had done 2 years earlier in the animal cruelty depiction case. The court seems to be through creating new categories of unprotected speech. But one of the reasons that the court gave in the video games case was that we have no history of protecting children against depictions of violence in our society. Indeed, violence appears in everything from Grimm's fairy tales to classical literature to television and movies and so on. In a sense, it's hopeless to try to root out violence that children are exposed to in whatever medium of communication you're talking about. The question of exposure of children to violence also came up in the FCC's report from 2007 about the prevalence of violence on television and what the government could do about it, suggesting that the Congress might want to impose time channeling of the kind that the FCC uses for indecency, and maybe require mandatory ratings so that parents would know what their children might be exposed to and could do something about it to avoid that exposure. That FCC report, of course, is not law. They didn't put out any new regulations based on it, and I think it would raise extremely serious First Amendment issues if the FCC did try to contain violence on television. The principal difficulty, of course, is defining the category of what speech should be restricted. How can you restrict depictions of violence in ways that can be even-handedly enforced and does not condemn materials that have great societal value, literary, artistic, political value, and so on. So that's injurious speech. Turn the page. Access to places and information. The only principal case that we looked at in some detail there was the Houchins case, Houchins versus KQED, that involved access to a jail by press and public, with the unhappy First Amendment result that the court shorthanded, it is true, that is, it was a 3 to 1 decision. The court decided that there is no such thing as a First Amendment right of access, not just to a jail, but to government facilities, government information in general. So that unlike some other countries we discussed last time that build freedom of information rules into their constitution, our constitution has none that requires the government to tell us what it's up to. But that's not the end of the story on access to government proceedings and information, because, as we discussed in class, 2 years after the Houchins case, the Supreme Court decided the first in a series of 4 cases during the 1980s dealing with access to criminal trial proceedings, where press and public were excluded from criminal trial proceedings. Judges simply cleared the courtroom and chased everybody out so that nobody could see what was happening in the courtroom. And in the 4 cases in the 1980s, the court decided that, despite Houchins versus KQED, the court did not cite that case, apparently thinking it was irrelevant as a precedent. The court decided in those 4 cases that, based on the long history of openness in Anglo-American criminal trials, they had always been open. People could go down and watch and see for themselves what was happening in a criminal trial. Because of that long history, there is a presumption of openness of criminal trials. History is one factor. The other factor is the functional or utilitarian or practical values of openness. That is, it makes sense in a real-world way to have criminal trial proceedings open so that people can see what's going on, be educated about the process. Openness discourages perjury, for example. Witnesses are less likely to lie if their neighbors are there eyeballing them, and discourages bias by judges and prosecutors. And finally, the court said that openness has a therapeutic value in allowing the people to see that justice is being done. So for those functional, utilitarian